Jackson, I. Mitchell.
Aye.
Mitchell, I. It has 4 votes.
That bill has 4 votes. It's out. Thank you, Mr. Floria. Next, we have Mr. Calra. We have AB 1425. Oh, I'm sorry, Ms. Ekman. I'm sorry, Ms. Ekman. No, for sure. We have Ms. Ekman with AB 168. I'm sorry about that.
That's all right, Mr. Chair. You just give me a perfect segue into talking about women's inequity in the workplace. You didn't see me. Oh, that's okay. That's okay. I'm easy to miss. It's okay. It's okay. I'm easy to miss, but now I'm here up in front of you. So, good morning, everybody. As we can see, it is inescapable that women are often overlooked in the workplace, paid less, and even when we're doing the same job, sometimes the outcomes are different. So this is kind of we're talking about the banning the ask of salary history when people go for a job. We know across the country, and we know, and I'm going to give credit to Senator Jackson, a lot of work has been done on this, but unfortunately we're still not as far as we need to be on making sure that women are paid the same for the same work, and also this issue of women's work in quotations mark, that women choose work that is lower paid. That is just another way of saying that we don't value the work of social work, dietary, all the kinds of things that women as caregivers sometimes flock to those kinds of places, but that doesn't mean that we should be paid less. As somebody with a master's degree in social work, I know many of my students who would go out with a master's degree, get a job in a CPS organization, were paid on average about $20,000 to $30,000 less than a young man going out into probation or into CCPOA, something like that, without a degree and making thousands of dollars more. So what this bill says is that basically, when somebody applies for a job, that we don't ask them what their previous salary history was. That's a way of double baking in inequity, and we think that is wrong. And again, while things have been done to improve this, we're still not there. A study last year found that African American women still make 65 cents on the dollar of a man, and Latinas only 54 cents on the dollar of a man. It's a nationwide study, full-time women. So in California, that translates into about $39 billion that does not go back into the economy because women aren't making that money. And again, as we know, many women who work full-time are women of color who are supporting families. And with me here today, we have Aileen Rizo to testify on this.
Good morning. Thank you, Chairman and members of the committee. I thank you for hearing my testimony today. Just this weekend was the anniversary of the Equal Pay Act. And over 50 years ago, it was signed, and we've been waiting for this discriminatory wage gap to close. I've worked in my field for over 20 years, and I have 2 master's degrees. I am a mathematician with degrees in both technology and mathematics, and yet I make thousands of dollars less than my male counterparts. And even though I had more seniority, more education, and more experience than they did. I know what it feels like to be the sole breadwinner for your family, and then to take less money home to your family than the man you're sitting next to. How did this happen to me when theoretically, with all the excuses that there are, that I did everything right? It happened because Fresno County Superintendent of Schools, under the direction of Jim Iovino, set my salary solely based on my prior wages. This perpetuated a wage gap that we've been fighting for decades. People opposing this bill will argue about frivolous lawsuits and the need to wait to see if other actions will work. I haven't seen one penny of the thousands that I lost in retirement and pay that I worked for 7 years for the county office. And yet my family has sacrificed thousands of dollars in legal fees for a case that's still pending. This is a fight that no woman should still be fighting in 2017. I couldn't educate myself out of being paid less. I couldn't get more experience or be in the job market longer to break the cycle because low wages will follow you wherever you go as long as someone keeps asking you how much you were paid. Many years ago, successful, intelligent, talented, and hardworking women of color got men into space. They did this despite the fact that they had to sit on the back of the bus and use specified work areas and restrooms. They did this under policies that allowed them to be paid less than their male counterparts. We still have made progress, but there's still work to do if here a woman of color is still fighting for equal pay. On behalf of women like me and their families, I urge you to support AB 168, because problems don't get solved by waiting, and haven't we been waiting long enough? Thank you.
Thank you. Additional witnesses in support.
Good morning. Jennifer Harms, the National Association of Social Work California chapter in support.
Thank you. All right, witnesses in opposition.
You can get back up here if they ask you for questions, okay?
Thank you very much.
Good morning, Mr. Chair, members of the committee. Jennifer Brewer on behalf of the California Chamber of Commerce, and we are opposed to AB 168. However, we totally agree that prior salary should not be the sole basis for any justification on wages or any wage differential amongst employees who are of different genders or of applicants who are of different genders, which is why we negotiated with Assemblymember Campos last year and agreed to amend the equal pay law to specify that prior salary by itself cannot justify any wage differentials. That bill was signed by the governor in fall and went into effect on January 1st, 2018, and we believe that that will have the anticipated effect of making sure that employers are not asking and basing our compensation offers on prior salary alone. Our efforts with Senator Jackson a couple of years ago was to make sure that the final offer of compensation to an applicant, the final offer of compensation that is given to the employee, is the key determination of whether or not somebody is being paid equal wages for substantially similar work. And that's why we supported that effort, because we believe that is the key determination and that it should be the key analysis. If somebody asks about a prior salary but ultimately receives higher compensation, that's to the benefit of the employee, which is why we think that prior salary is still a relevant consideration. Most of the times employers don't have accurate market data as to what employees are being paid for certain positions. A lot of employers want to make sure that they are incentivizing and appealing to an individual to actually leave their current employment and come to a new job. And that's why prior salary is often asked for an applicant, to make sure that they are paying them more and incentivizing them to come to work. I would suggest that SB 358 won't let them do the reverse any longer, and the bill that was negotiated and amended by Assemblymember Campos here in California won't let them do the reverse. You can't ask about prior salary and then justify any wage differential or a lower compensation offer to an individual, because SB 358 bans that from happening. You have to pay equal pay for substantially similar work, and not SB 358, but our equal pay law, as amended last year, specifies that you can't justify compensation on prior salary alone. So we believe those practices are actually banned. With regards to disclosing upon a pay scale, again, that is an arbitrary amount, and an employer may not feel able to go above the pay scale determination or below the pay scale determination when they have applicants that may fall outside of that pay scale, to give them an opportunity to come to work. And so we're concerned with that as well. Our final consideration is, because it's in the labor code, it triggers the Private Attorney General Act. And even though you can have a technical violation of either of these two provisions that ultimately don't harm the employee or the applicant, and that they're actually offered more compensation than their prior salary and are at the same level as everyone in the workplace who is performing substantially similar work, you can still have a lawsuit that is costly to the employer, even though there's no harm to the applicant or the employee. And for those reasons, we are opposed.
I think you have a question. Well, thank you, Mr. Chair and members. Mike Belote on behalf of the California Employment Law Council. I like to think that CELC members are the state's largest and most responsible private employers. And I wanted to talk for a minute about what is happening out there. And I go to their meetings and I go to their seminars. First of all, you would see an incredibly diverse room. These are California's leading HR and employment law specialists. More than half the room is women. And what is happening in response to Senator Jackson's bill and the follow-on bill, which expanded the law to race and ethnicity, is incredible efforts at compliance across California's biggest employers. I have watched them talk about the self-audits that they're conducting. You have tens of thousands of employees in California, and they're talking about how to properly evaluate wage differentials. And I'm telling you, you'd almost need a degree in statistics to follow the efforts that are happening to make sure that even the tiniest wage differentials are addressed, and how to address them properly without falling afoul of other laws. This is an incredible effort that's going on right now. So please understand that the efforts that this legislature made are being taken very, very seriously by California's biggest employers. Now, I'm a little concerned about the breadth of this bill. It says you cannot inquire about prior salary or benefits. In the recruitment world, often they're going to try to attract other employees to jobs that are under filled, and they're going to say, tell us about your, for example, your pension plan, your profit sharing plan, so we can try to meet your needs. It appears to me that that would be unlawful under the bill. It says salary or benefits. So any inquiry into that person's employment package would violate the law. We think it's overbroad, and we don't think, respectfully, that it takes into account all the efforts that are being made now. I don't know why I guess I ran over here. All the efforts that are being made now to comply with the gender law and the race and ethnicity. Thank you.
Additional witnesses in opposition.
Good morning, Chair, members. Ken DeWorth, the National Federation of Independent Business. And while what happened to the first witness was pretty bad, I mean, I agree. I think that's been fixed by current law. That can't be a factor, the determining factor anymore. And we don't need another right to sue small businesses. Thank you.
Thank you. Next witness.
Good morning. Katie Hansen with the California Restaurant Association. We're opposed as well. Thank you.
Nicole Rice, California Manufacturers and Technology Association, and respectfully, we are opposed.
Danielle DeVoe Sires, Civil Justice Association of California, also in opposition.
Richard Markison for the Western Electrical Contractors Association and the American Petroleum and Convenience Store Association, two entirely different industries, both with the similar concerns. We're opposed.
Great. Okay, seeing no more witnesses in opposition, bring it back to the committee. Question, Senator Jackson.
Well, deja vu all over again, actually. Same opponents, except I do want to commend the chamber and Ms. Barrera, who helped us get to yes on our fair pay legislation. I hope that she is right and that those in opposition are right, that the people are going to be judged on the quality of their work, but that's just not the reality. And I hope going forward that will be the case, but it seems to me that we need to make it clear. And I wonder if I may ask the author, is there anything in this bill that prohibits a prospective employee from asking or from indicating that they are actually looking for a job that compensates, as the question, more than what the prior job is that they had? For example, the job pays between, let's say, $60,000 and $80,000 a year, and they're making $85,000 a year. Is there anything in this bill that prohibits the employee from saying, I'm making $85,000 a year, now I'm looking for a job that's going to pay me more? Is there anything that prohibits that?
Not a thing, Senator. What this bill does is allow women the ability to be able to ask for what they think that they deserve. And it's interesting on this bill, I had bipartisan support in my House, and the Republicans who got up and spoke for it are all business owners who said you offer somebody what the job is worth, no matter their gender. That's what equity is about.
And I think that until time passes and there are extraordinary efforts, I have to say I am so pleased to see the responsiveness of the business community and efforts being made to try to correct what I think most companies and people realize has been an inequity, so that there have been enormous efforts to create these metrics and systems by which we will assure equal pay for substantially similar work. And so I know that we're moving in the right direction. It seems to me that people will ask, what have you been paid? And we see it here throughout the state, throughout our both the private and the public sector, that jobs are being offered based upon prior salary. And we know for women that is just the kiss of death, because women tend to start off at lower paying levels and then work their way up. And I know, Elaine, I just thank you for being so persistent. This is the perfect example of a situation where gender stereotypes, and I don't think it's necessarily intentional. I don't think it's evil and vicious. I just think it's built into our social fabric, and we need to fix that. And so I certainly support this effort. I don't think, all this talk about, there'll be more and more lawsuits where there's no harm. People don't bring lawsuits when there's no harm. You get nothing out of it. I mean, that's kind of silly to me. You have courts, we have to give a little more credit to our judges. If there's no real cause of action and no damages, the courts are busy enough as it is. So that argument I just find is one that's frequently used, but I don't think has any merit. And I think it's interesting that, as Mr. Below pointed out, that these HR conferences, more than half of the people there are women. It's not an accident that in the HR field, it's mostly women. And I would submit that a vice president of a company who's the head of HR isn't paid anywhere near what the vice president of a company doing something else is paid. So I think that more likely makes the case than overcomes it. The self-audits that we're seeing, I think, are terrific. I think if we added in there the element that you can't ask about prior salary, a job pays what it pays because that's what it's worth, I think is important. And yet, if there's someone who wants to be paid more than the job is paid, has the right to say so, but not the other way around. And I would think that this is definitely just another tool in that toolbox. I have one question, though. I know that Massachusetts and New Jersey have passed laws prohibiting this. Do we have any information on how that is being implemented and its success?
I think we're still getting the
Still
numbers back
seeing,
from them.
okay. I know in Massachusetts, I was at my niece's wedding last year, and Massachusetts here, my niece was boasting about our bill here, and a friend of hers who was more knowledgeable identified that Massachusetts was even farther ahead of us. That pierced my bubble. But it was still a nice wedding. So I just think that, lower wages do follow you wherever you go, and they shouldn't. And again, I don't want to marginalize the work that's been done, and again, want to thank many of the folks in this room who are opposed, and particularly give a shout out to my friend over in the chamber for her good work. But I think we really need to move in this direction, so I'll move the bill.
Thank you. Senator Mitchell.
Thank you. It just struck me. I'll be proud to support the bill today, Assembly Member. But in listening to Senator Jackson's comment about, sometimes perhaps it's not intentional. And I was reminded about two hearings that a select committee that I chair held in conjunction with this Labor Committee and the Women's Caucus on implicit bias and the research that's coming out of Cal and Stanford on the role implicit bias plays in hiring practices, promotion practices, and job evaluations. The job evaluations research really just struck me how, a woman, the way a woman's stellar performance is characterized. Well, she, and perhaps credit should be given more to the team as opposed to her individual leadership. And so the reason we have to continue to legislate and push the envelope and push the industry to do the right thing, because implicit bias is real. And until government steps up to shake things up, to require that people check their own bias and develop policies to protect underrepresented classes, then we'll never have any difference. And so while I appreciate that the industry is moving at light speed, keep it up. And we'll keep up the pressure to make sure that they continue, because we have generations to make up for. So I'm proud of you and to support the bill today. Thank you, Mr.
Senator
Chair.
Mitchell. Any additional questions? Senator Vice Chair Stone.
Thank you, Mr. Chairman. And, I was a strong supporter of Senator Jackson's bill to ensure equal pay for equal work. And I think with these laws on the books, I think it gives appropriate recourse to address the situation that this young lady mentions here today. But I will disagree with my colleague from Santa Barbara that litigation against small businesses is not a factor. We see frivolous lawsuits commonly being filed against employers that cost these small employers significant sums of money. And all you have to do is look at the American for Tort Reform's list for the nation's top judicial hellholes, and California ranks number 1 or number 2 regularly on that list. As a small business owner, I can tell you I can't afford to spend $100,000 to defend a lawsuit especially when you have specialized entrepreneurs like myself that have a business where we make a lot of drugs, we make a lot of medications, and there's a lot of facets to our industry where I hire a lot of pharmacy technicians that I train them to do specific things. I may train them to help make sterile products. I may train them to do encapsulations. And many times when you innovate the way you make things in my industry, sometimes there is no person in the community for which you can compare them to. So getting a history of what they've been making and their benefits package, if that is a worthy employee that you want to bring on, obviously you want to do something better than they've been receiving before, even though you may be setting a new standard for that specialty within that profession. So I appreciate the goal that you're trying to accomplish here, but I think that the goals that you're trying to accomplish are already enshrined, if you will, in legislation that gives the proper legal recourse already against businesses. And so I don't want to create a more litigious environment for businesses that are already struggling in the state of California to stay here and not flee the state. And for those reasons, I can't support your legislation.
Great. Thank you, Ms. Ekman, for this measure. I just want to respond to the comments that Ms. Barrera made in her presentation. AB 1676 by Ms. Campos was passed. Ms. Barrera said it doesn't go into effect till 18? Yeah, okay, that's what I thought. It's already in effect. What are your thoughts about looking at how that bill rolls out this year and listening to the argument of just letting that take effect before bringing this measure forward?
You know, Mr. Chair, that is a fair question. You weren't here last year. I wasn't part of this negotiation last year. When the bill came forward, it was negotiated, this part was negotiated out, which is why you don't see a lot of supporters behind us, because they honored that a negotiation was done. I wasn't a part of that, and neither were you, and neither were millions of women in the state of California who still suffer. And while I respect that people are doing their best, and I respect that many of the advocates stayed out, I think it's up to us as decision makers and policymakers, as Senator Mitchell said, to continue to press this envelope. I have at least I had two young staffers, women of color, who are now across the street because I could not pay them what I was offering their male colleagues, their male counterparts, doing the same job. I couldn't match that based on their former salary history. I know this is real. You know this is real. I think we all know this is real. And while a negotiation was done last year, it didn't go far enough. And if in California we're not going to be the leaders, then who is?
I agree. Thank you. Senator Jackson.
Yeah, just in response to my good colleague from Temecula. That meme about creating more lawsuits is so old and so stale. California continues to lead the country as the 5th largest economy in the world. I have greater confidence in our courts that when quote-unquote frivolous lawsuits are filed, they are thrown out, and they are. So to look at the National Tort Reform Association, which is clearly ideologically not in, how would we say it, not unbiased, and keep quoting that. I find myself, I've listened to this over and over again, and with all due respect to my good friend and with great respect for the work and the business that you have, your business, being unique as it is, would be justified in bringing on someone at a particular job level because of that expertise, and I don't think anybody quarrels with that. So what we're looking at here is, for example, a job that says the pay is between $70,000 and $80,000 a year. Maybe if I may ask the author. The pay is between $70,000 and $80,000 a year. I'm an employer. I say to a prospective employee, the job pays between $70,000 and $80,000 a year. Is that okay with you? And they can say, you know, Senator Jackson, I'm making $90,000 now, so obviously I would need more. Nothing wrong with that. But if I, as the employer, said, the job, we're offering it at about $60,000 a year, what are you making? and that person says, well, I'm making $45,000 a year, then suddenly the conversation shifts. Or I don't say at all what that job is likely to pay. I think I'm going to have to pay $60,000 to $70,000, and somebody comes in and I say, what are you making? And they say, I'm making $45,000 a year, and now you can offer them less than what the job is paying. And that's been part of the problem. It's not that I don't think that anybody's intentionally undermining paying women fairly. I'm sure there are some who do. But that's part of the problem, is that because we start off at a lower level, suddenly we can never catch up. And so I think that's what this bill is about. It isn't about litigation. It's about fairness. And I would like us to get back on that topic. And as I said, that you just... You know, we have a system of justice here that is not abused, and when it is abused, people come before us, and there are lots of good lobbyists here and people who will bring those issues to us to make sure we're aware. The scale is not tipped in favor of the employee in this state, but the scale should be balanced equally between all sides, and I believe this bill continues that tradition. With that, I conclude my remarks.
Thank you.
Yeah, thank you,
Senator
Mr. Chair. Just to continue on with the dialogue, I am an employer. I have been the beneficiary of frivolous lawsuits. You're absolutely right. If it would have gone the distance to the judge would have thrown it out. But until we get to that judge, I still had to put $25,000 in a retainer and fight the frivolous lawsuits, which are more than one. And it does cost small businesses a lot of money to defend frivolous lawsuits until such time that sometimes it's better just to pay down the request as much as you can to try to alleviate it going to the judge with significant legal fees for the judge to get to the determination that you said, you're right, this is frivolous, it should go out. My attorney doesn't say, oh, we're going to refund your fees because the judge found that our lawsuit was frivolous. So you ask anyone in the business community, why are there so many chambers opposed to this bill? And they're opposed because of the litigious nature that we create in the state of California that creates such easy opportunities for people to go after employers. Now, the bigger employers can afford to deal with this. I'm worried about the smaller guys like myself that are throwing their hands up and are trying to figure out ways in which they can survive in the state of California. This is covered under PAGA. This is opening the door to very expensive litigation. When again, I think we have laws that cover, we have laws that are newly enacted. We haven't even seen how they effectuate the goals and aspirations of what we're all trying to accomplish. I'm with you, equal pay for equal work. But we can't continue to open the door for frivolous litigation that is costly to small employers that in many cases can't afford it, and in some cases will throw up their arms and say, we're closed. So I will respectfully disagree on that.
Senator Atkins.
Well, thank you, Mr. Chairman, and I was content not to get into the conversation because I thought everybody was doing a pretty good job without my voice. But I would just say, you know, my spouse is a small business owner. She owns 2 small businesses. And, you know, the conversation really is about this is a systematic problem. And in her business, you know, the market really does kind of drive the salaries overall. But then there is the issue of, and she's had conversations with me about when she looks at the marketplace and attracts the best and brightest to do the consulting work that she does, she sees in the industry that she's in that there is a disparity. And so she's made a commitment, and yes, it costs a little bit to get to that point. It's costing us a bit in this in government to look at the Assembly and the Senate and figure out how we're going to address the fundamental inequality in terms of what has happened over time. And it's happened for a variety of reasons. Sometimes we get budgets. Everybody has a budget that you have to work with, and you're hoping you get the best for the budget you have. And then you have to make a moral decision when you see your options as an employer. Gosh, I can get this really great person, but this is all I have to pay. and this is my budget. If we don't structurally and systematically start to address those issues, we'll just continue along in this manner. And I think, and it's not easy to make change. It was not easy to have the conversations about raising minimum wage and what that would do and the impacts and how you address it over time and the smoothing effect, if you want to use that phrase in this regard. But if we don't do that, we're going to continue to create inequities in the economy that really hurt families and overall. And so while I do get the dilemma and the difficulty of change having to take place in a way that gets us where we need to go, I think there are small businesses that understand and, that it is about the values of rewarding the work that is done appropriately. And we've seen the studies that talk about employees when they are well paid for the work that they do. There's higher productivity. And so I understand the difference. And in terms of the issue of frivolous lawsuits, lawsuits based on personnel issues, we are finding in this day and time that what also benefits the employer as well as the employee is to really understand the nature of work and also how the law factors into that. I'm not an attorney, but I just think practically when you look, I have been a manager of a nonprofit clinic and had to hire doctors, nurses, and medical staff that were not licensed staff, but at a different level, medical assistants, trained but not professional staff in that regard. And, you have got to be able to address these issues holistically and get there. And I think you have done a good job. I think your last set of statements was the perfect close, actually, for where we are. And this is not easy stuff, but I do think it is possible. And I do think there are small businesses, and it has been a struggle for her. She is now a decade in these two businesses, and but she feels really good about the product. Her staff is competitive, and they are becoming competitive with those big organizations now. But that is in part because of the decent benefits, the wages, and we've got to take care of this now. Otherwise, we'll continue to see these issues and lawsuits. I think this causes lawsuits. The inequity and the unfairness actually creates lawsuits that wouldn't need to happen if there was the addressing the issue holistically, systematically. So I support this. I appreciate the dialogue, but I think we really need to move forward and get underway and do this for the good of all employees.
Thank you. Senator Mitchell.
Thank you, Mr. Chairman, for allowing me a second time at bat. With all due respect to Ms. Eggman and the bill before us, I think we are mixing apples and oranges. And the question that needs to be answered is, how do you appropriately value the work? Ms. Eggman contends in her bill that it should not be based on my previous salary doing different work. And so it has been corporate governance best practice for years that has come to the fold more recently with questions around the appropriateness of CEO compensation. And so all businesses, be they unique, be they widget makers, be they large or small, fundamentally understand that you have a responsibility to do a market analysis on a regular basis to determine the value of the job. And I get that that's what this bill is attempting to do, to make sure that the value of the job is what drives the salary being offered whoever comes into the job. And so, frankly, frivolosity is in the eye of the beholder. I am sure your witness has a different lens about whether or not her lawsuit would be valued, appropriate, or perceived by someone else as frivolous. So that's not the issue from my perspective at hand today. How do we determine the value of the work? And whatever the work is, there is no job so unique on the planet that someone else, somewhere, somebody else, someplace else isn't doing something similar that A market analysis could give you a range. That's the issue at hand. Is it appropriate to determine the value of the work based on what I was paid doing another job at another time? There is no logic in that. Again, that's why I'll be supporting your bill.
Thank you.
Thank you, Senator Mencho. I see no more debate. Would you like to close, Ms. Eckman?
I will let this fine conversation stand as a close.
Great. I would only add, I hope my salary here doesn't follow me once I leave here. Madam Secretary, please call the roll. We have a due pass.
Based on what I made before.
Amen. I understand. We have a due pass to Rules Committee for consideration for referral to the Purge Committee. Madam Secretary.
Bradford?
Aye.
Bradford, I. Stone? No. Stone, no. Atkins?
Aye.
Atkins, I. Jackson?
Aye.
Jackson, I. Mitchell?
Aye.
Mitchell, I.
That's out, Ms. Eggman. Thank you for your
very much.
presentation. Thank you as well. Next up, we have Mr. Kalra, AB 1425.